It's a hassle. And you promise the court to take out the case.
For your birthday, I'll give you a big present. Now I need to do that side. How do I give it up? No. On my feet and everybody else is Profe, So, salam prof morao. Emang kalau udah
As please of worship, state court case number 20A/113/2023. State against Senoe Ishmael Matswara. There were James Dipolo. Nandipha Magudumana. Motenyani John Masukel. Theo France Mahotsa. Natasha Johnson. Your Worship, there are two accused that the state requests in terms of Section 157 of the Criminal Procedure Act that they be added to the charges as accused number 7 and 8. And I would therefore thereafter ask that each of the defense attorneys confirm their appearances
Theo France Mahotsa. See you, sir. Nastasia Hansen. This is an application by the prosecution for both of you to be joined to this case under case number 20A/113/2023, following the provisions of Section 157, subsection 2, Section 157, subsection 1 of the Criminal Procedure Act 51 of 1977. Do you understand?
That is you. I understand you.
Number 8. You are accordingly joined to this charge, and Mr. Theo, you will be accused number 7, and Mr. Janssen, you are accused number 8. Right, Mr. Theo Mahot, you've got the rights to legal representations. You may appoint an attorney at your own cost. If you can't afford to pay one, you may make an application to the Legal Aid Board to be assisted of an attorney free of charge.
My apology, I omitted to mention that Mr. Mururi is here for accused number 7. It's only accused number 8 that I was not made aware of her legal representative as a cases.
Okay. Before I further explain her rights, is there any legal representative of accused number 8 before court? None. Madam, you've got the rights to legal representations. You may appoint an attorney at your own cost. If you can't afford to pay one, you may make an application to the Legal Aid Board to be assisted of an attorney free of charge, or you may elect to conduct your own defense.
you understand what I'm going to do?
They actually were supposed to attend
May you rise up your voice?
there was an attorney yesterday that was appointed by SABC, so I don't know why he's not here.
You don't know who the attorney is.
No, he couldn't say me because I was not charged.
Then what are you going to do?
Legal aid.
Legal aid. Is there any legal aid practitioner?
May I please approach your worship?
You may approach.
Your worship, unfortunately due to the congested court, I don't know if I'll be able to take instructions in this manner. I don't see it being very professional at this stage. May this matter then just stand out. I need to take proper instructions from accused number 8, your worship. I cannot consult with her, cannot obtain any instructions from her because this courtroom is so congested, your worship. Please, your worship.
Right. Point taken care of. I will revert back to that issue. For accused number 1.
Mr. Court pleases your worship. Your worship, I confirm my appearance on behalf of accused number 1 and accused number 7 respectively. Kahisho Mururi from Mururi Attorneys, your worship.
Thank you, Mr. Mururi. And for accused number 2.
No, should be accused 3. Accused 2 and 5 are not before court. Your
Yeah,
worship.
thank you,
As it
Mr.
pleases.
Matuki. Accused number 3.
Thank you, Worship. My name is Sotleho Makamedi. I'm from Legal Aid South Africa, not Legal Aid Board, as the court has been saying. Legal Aid South Africa, and I'm appearing on behalf. I confirm my appearance on behalf of accused 3. Thank you.
Mr. Tsokolom
Sotleho Makamedi.
Makamedi.
Yes. Thank you, Worship.
Not from LAB, but from LASA.
No, not even LASA. If you want to use the acronym, rather say Legal Aid SA.
All
Not
right.
even LASA.
Thank you.
Thank you.
All right. For accused number 4.
Ryan Ishmael, Your Worship, RC Ishmael Attorneys. Your Worship, my office is on record for accused number 2 who has been excused previously and accused number 4. But today I will request that my office withdraw as attorney of record for accused number 4. My learned colleague Mr. Motlongi is going to come on record. That has already been discussed with the accused person and accused 2, and the arrangements were made before coming to court today. I believe Mr. Motlongi can address the court further. As please the court.
Okay, application granted. Mr. Mutlu.
May it please the court, Your Worship, I confirm that I appear on behalf of accused number 4 in this matter. Your Worship, I just want to also indicate that I am from Machini Mutlu Incorporated Attorneys. I received instructions on behalf of accused number 4. Your Worship, to also place on record that the accused number 4 will be co-represented by myself and Advocate Dlamini. We have canvassed this issue with the state, and thus the state is fully aware of this arrangement. Then give space for my learned colleague, Advocate Dlamini, to place himself on record as well, on behalf of accused number 4, as a practices.
Thank you. Daniel?
Court business, Your Worship, I confirm a brief from Mutlu Attorneys. My name is Franz Dlamini. I'm from the Free State Bar, and I've accepted the brief from Mutlu Attorneys in relation to accused number 4. As a pleasure.
Welcome. Accused number 6.
May it please the court, Your Worship, I confirm appearance on behalf of accused number 6. I am Masilo Kwenani from Kwenani Attorneys. Please.
Thank you and welcome.
Your Worship, may I interject? My name is Jacqueline De Vries. I'm from Legal Aid South Africa, Bloemfontein. Legal Aid was on record in this matter. Our mandate has been terminated. after consultation with accused number 6 today, and then Mr. Kwanani will then take over from here. As the court pleases. I only request to be allowed to withdraw as attorney of record. As the court pleases.
Application granted, madam. Thank you. Right. Mr. Matuba, there is an application by Mrs. De Vries for matters to stand down so that she can properly take instructions.
I think that's only fair, Your Worship, and I have no objection there.
Thank you. How much indulgence?
Your Worship, if I may, I have about 15 minutes. The problem is just I won't be able to consult here, or if we can just be, if I can just be allowed some privacy with my potential client, I would appreciate that.
Okay, that will be dealt with
Yes,
in my
I
absence.
want to suggest that maybe we can use that opportunity if accused number 8 so wishes, that she be allowed to make contact and to establish who this attorney was that she says wanted to see her yesterday, so that we get clarity and to assist her in contacting the relevant attorney as it pleases the court.
Thank you. Much appreciated. Okay. Court adjourns.
All of them. Mavan.
How are you?
Good and you?
I'm good. Okay. It is okay. It's number 8.
Okay.
Contact number ya cancanta da wanda nan ga hawa samsin ba wacin shi number
444. Wena le maobo no lla ka
Baska ba ke ya bana
a udula lla re
Ya futhumala. Ya futhumala.
We just had a few tellers.
Jackie, you're too far, my dear. Remember, you now have to address the court in terms of whatever. Okay. Thanks. Thanks, Jackie.
Jackie, just went out of the office because we wanted to be on TV.
There's something. Everything, yeah.
Available after lunch today. What's Ama?
I'll give you a call.
Okay.
We'll arrange.
All right, court.
As please, Court, Your Worship, may I recall 20A/113, 2023, State Against Noe Ishmael Batswara and others. Thank you. Advocate De Vries. As it pleases.
May it please the Court, Your Worship, it appears that private representation has arrived for accused number 8. As the Court pleases, Your Worship.
Who is the legal
May this honorable court, Your Worship, for the purpose of record, the name is Itabe. I appear on behalf of accused 8 today, henceforth. As the court pleases, Your Worship.
Thank you.
Apologies, Your Worship, I do not have a chair, so I'm not standing to bring in. I will raise my hand if I need to draw the court's attention.
As please the Court. Your Worship, the matter is before you today for bail application. That was in respect of accused number 1, 3, 4, and 6. And in respect of those accused, Your Worship, for bail purposes, the state was ready until these new developments where accused 7 and 8 had to be added to these charges. Your Worship, I must indicate that prior to us coming to court, we had a little conferencing with the rest of the defense attorneys, except for the attorney for accused number 8, who only comes into record now. There were discussions in terms of the possible dates and the readiness of the parties. We have reached an agreement for the postponement of the matter, and that will be to afford the state an opportunity to gather bail information in respect of accused number 7 and 8. Furthermore, Your Worship, Mr. Kwenani also comes into record for the first time here today, and he also indicated at that stage that he needed to first consult and to be ready. And we could not agree on dates. The discussions evolved around the 16, 17, and 18. But I've now since learned that the proposed dates are 10, 11, 12. The 10th I'm not available. The 11 and 12 it's suitable to the state. We did not converse this with the new representative for accused number 8, Your Worship. So the state will request that the matter be postponed to 11 and 12, those 2 days for bail applications. Your Worship, there was also a concern I should mention upfront by the defense team that what will happen if on the next date there is also further new development in terms of the possible arrest of further suspects in the matter. The prosecution has given them assurance that in respect of the accused before court, we will proceed irrespective of whether there are new accused to be added or not. And in terms of that, we will of course cross that bridge when we reach it. But for now, the agreement is that the matter be postponed to the proposed dates, that being the 11 and 12 of May, as it pleases.
Mr. Court pleases, Your Worship. Your Worship, I confirm in essence what my learned colleague has placed on record. Safe to say, Your Worship, I'm instructed by my client that bail by its very nature is an urgent matter, and he would prefer that this bail application be dealt with the sooner the better. We do fully understand the predicament the state finds itself in, and as such, Your Worship, we remain in your hands, but we would propose, and given the magnitude of and the number of the accused persons, I do not believe that 2 days would suffice for a bail application hearing. We would respectfully propose the date of the 10th, 11th, and 12th. That is for a formal bail application. My learned colleague is not available, and I accept that, Your Worship. But one can only make the submission that it's not a partly head matter. I believe the state would have the resources to take it on, should the court so be willing to grant my request, and that is my submission, Your Worship. Mr. Court pleases.
In essence, you agree with the proposed date?
Indeed so, Your Worship. Well, with the inclusion of the date of the 10th, that would be the Wednesday. So if it were to run 3 days and not just 2 days, because my learned colleague says he's available on the 11th and 12th, and that's just 2 days. I do not believe that we will finalize this bail application within 2 days. We had discussions as the defense team, and we were of the view that we would need 3 days for us to finalize this.
Will there be anything that prevents it to go beyond the 12th?
Well, not at all, Your Worship, but like I say, then that would mean that there's a further delay, and between then and the date on which the court hands down judgment, the accused persons remain prejudiced and they remain in custody. Mr. Court pleases.
Thank you.
Mr. Court pleases.
Mr. Makamil?
Thank you, Your Worship. Your Worship, I echo sentiments by my learned colleague for accused 1 and 7, and I agree to the dates, with the inclusion of the 10th as a possible date for hearing of the second application. Thank you.
Scott, please, Your Worship. Your Worship, I am okay with the submissions made by my 2 learned colleagues, but however, we also wish to add the following. Your Worship, that there are a number of accused, as a result of which it will take quite a long time for them to present their cases. And it will also take a long time for the state to present his case. But what's important, again, Your Worship, is that number of charges we discovered today that they have been added, which was not the position on the last appearance. And the other thing is, Your Worship, that when this matter was postponed, it was actually postponed until today for a bail application. The applicant was ready to proceed, but however, we accommodated the state in the sense that they added further charges which were unknown to the accused. More so that they added further accused. So that is a compromise from the side of the defense. But to only postpone this matter for 2 days for bail application in the light of the number of applicants, it will be prejudicial to the applicants. And it is for that reason that we submit that at least 3 days. It will enable us to have a very great progress on the matter. And for that reason, Your Worship, we submit that it is not a partly yet matter like my colleague had said. The matter will be starting afresh. So anybody can do it. So it is not that because maybe by the 10th, my learned colleague for the state is not available, that the whole matter or the accused should be prejudiced simply because he is not available. So we are saying there are liberties of the accused which are at stake. The matter is urgent. The matter ought to have proceeded today, but because of the reasons which I have already advanced, then the matter is postponed. And what must be clear, Your Worship, is that this matter is not postponed at the instance or at the request of the applicants. The applicants are not asking this matter to be postponed. And the question is, who is asking this matter to be postponed? Because the record says, in particular, accused number 4, the matter is postponed for her to make an application. And it's not for bail, and it's not before this court to say now he is applying for a postponement. The question is, who is applying for a postponement? And on that basis, we are saying 2 days is not enough. We request 1 more day to make 3 days.
But, Mr. Dlamini, I would ask and say quo vadis now.
Yes, sir.
Yes, quo vadis. Because you have already indicated that you share the same sentiments with your learned friends.
Yes.
Now it appears now you are extending it to indicate a particular argument. Can we deal with the issue of the postponements per se, whether you have reached a consensus or not?
Yes, with regard to postponement, we have reached a consensus, but the problem are the dates. So the state is saying 2 days, and we are saying 2 days is not enough. We want 3 days, and we have given reasons for that. And we are saying we are not the cause for the postponement, and for that reason, we request the court to look at this matter and put some sense of urgency in that bail application by its nature is an urgent application. Thank you.
Thank you.
As a court pleases, Your Worship, I just want, in supplementation of the submissions made by my learned colleague, Mr. Dlamini, and other colleagues, just to take the court into the processes that led to this argument, is that the state and the defense are both in concert with regards to the duration of this bail application. That the type of matter that is before this court, the number of accused that are before this court, a myriad of issues that both the defense and the state are in concert with, to the extent that a date which was initially agreed on incorporated 3 days. Now, obviously, if those dates were found not to be suitable to the defense, some of the defense legal representatives are not available on those dates that the state proposed. What we are left now with was to look at the alternative dates. And in this instance, what really drove us to identify such dates was the urgent character of bail. And in this instance, we moved the dates forward with a view of still going along the lines of having 3 days for purposes of bail application. Now, if we were to deviate from that, we would have to zoom into the reasons why we are deviating. And the only reason is non-availability on one of the days. And it cannot be that we will allow the matter, therefore, to even overlap to the next available date, which may perpetuate, further incarceration of the accused, thus trampling on that very same essence of the agency of the matter. It is on this basis, Your Worship, that I would submit strongly that the state needs to accommodate the defense in this instance. The 10th and 11th and 12th are the dates that would really see this matter make significant progress. We wouldn't even know if at that time we would have finished the matter. But we know as a matter of fact that 2 days is inadequate for purposes of these proceedings. It is thus my submissions, Your Worship, that the state should consider the objection, it's not even the objections, the submissions by the defense, submission which we are riding on the discussion that took place off record, where we agreed on 3 days as the court basis.
Yeah, Mr. Matoli, it is argued that 2 days will not suffice, but it is suggested that 3 days may suffice. Is it correct that it is not also certain whether 3 days will suffice?
Indeed, that was my submission as well, Lordship, to say we are not even sure if the 3 days will be adequate.
Meaning this bail application may also take 5 days. It's possible.
We can't rule out that possibility.
Thank you.
Yes, but we will perhaps adopt the same stance that, we will cross the bridge when we get there. And for now, the earlier we handle and deal with bail application, the better. Taking cognizance of the urgent character of bail as a process.
Thank you. Mr.
Please the court, Your Worship, I shall not belabor this matter any longer. Two things are clear, Your Worship. The first one is that we need more than 2 days. 3 days have been suggested. Possibly it could even be more than 3 days. But the minimum that we would like to appeal to this honorable court to give us would be 3 days as the minimum. It would be improper, and this is our submission, that because the state, one of the prosecutors representing the state will not be available on that particular day for whatever reason, that these accused people our client should be held for ransom for one person. We therefore suggest that if a Leonard colleague would not be part and parcel of these proceedings, that the state has got plenty of resources and people that are also quite capable like him to proceed with the matter. So, our pleas to this honorable court, give us 3 days, allow our Leonard colleague who would not be there, not to be there, but the state would replace him because it is what a number, we believe, of capable people. I shall not belabor this one.
Thank you. Advocate General.
As the court places Your Worship, it is quite clear, it is on record that I was not in here at the onset of the matter, and I take also cognizance that even there, during the deliberations with my eminent colleagues, I was not of the part. I'm not to be suspending my diary. I've been tenterhood. In terms of where I come from, the Swazian is less deep, so I could facts speak for themselves. We take cognizance that this matter has been on a roll for quite some time, and that bail is urgent on this current. And I concede that I place everything aside, and then I deliberate on the 10th to adhere to the dates as set out by my learned colleagues. That will be the 10th and the 11th, and I'm 13th. I can't say more. I think my colleague advocate Andamene has said a mouthful. I agree with them. I agree with them that it is set for 3 days.
Yes.
And the court basis.
So it is clear you are available for those dates since you are not part of the discussion.
Indeed, Your Worship.
Thank you. Right. Audi alterum partem.
Joseph, a lot has been said, and I'm not objecting to the sentiments by my learned friends. I'm quite aware that bail application is an urgent matter, and I need to emphasize that insofar as accused 1, 3, 4, 5, and 6, the state was ready. We are even ready now to proceed with the bail application. It is not that the state, like one of the attorneys or defense said, that the state cannot hold these proceedings at ransom because of the absence of one person. That argument is neither here nor there. All that I'm saying, Your Worship, there has been some discussions, and the discussions earlier evolved around the dates of the 16, 17, 18. The dates of which were suitable to me, to all parties. It's only when we were in court here that I heard the mentioning of 10, 11, 12. And I whispered to my learned friends that says, The 11 and 12 is suitable to me. The 10th, unfortunately, I'm not here. I do not appoint myself to this case. I have been assigned to be the prosecutor responsible for this matter. So the question of holding the proceedings at ransom is neither here nor there. Joseph, the duration of the bail application, of course, no one can say how long this bail will take us. And I want to believe that even if we agree on the 11 and 12, we can as well reserve 2 further dates in the week thereafter. And we have 4 days. That does not impact on the agency of the matter. I want to believe, Yoshi, that the 11, 12, and we can also look at the further days that were already thrown into the table, which is 16, 17, 18 for the bail application. That's my take, Yoshi. As it pleases.
Thank you. I believe no reaction.
Your Worship, I'm tempted to really react, particularly for purposes of accurate capturing of this information. Yes, indeed, dates were arranged as alluded to earlier through my submissions. But what is really inaccurate is the fact that these alternative dates, which brought forward the bail application, were only communicated, later on. Actually, they were even canvassed as we were looking at these dates. But there was the reason why these dates were not suitable, were not agreed on, was that some of the defense legal representatives found difficulties in being available in one of the dates that were initially proposed. So it's not an issue of just having moved away from the initially agreed dates. Those dates were provisionally proposed with a caveat that the defense should then look into their availability. And when we found to the contrary that some of the defense attorneys were not available, we then made that proposition. So whatever that took place, the discussions and debates or arrangements between the defense and the state was all but in good faith, and the dates that had then subsequently been proposed, those are the dates that the defense genuinely is available. Yes, we may have a situation where there is an overlap, but Your Worship, let's cross that river when we get to the bridge. For now, what we do know is that this bail application has to be entertained as a matter of urgency, and therefore coming to court and deal with this bail application at the most earliest date available would really satisfy that requirement of urgency as a basis.
Ruling. After listening to both the prosecution and the defense team on the aspect of a date for bail application hearing, I come into the conclusion that it will be in the interest of justice for this court to adjourn the case to the date of the 12th, rather the 11th and to the 12th. It is clear that the duration of this bail application cannot be guaranteed at this juncture. I do understand the agency that is being referred to by the defense team. However, the inception of this bail application will be at least after a day, of which it is the day of the 11th, other than the 10th. The reason for this is because it is given, as the public prosecutor has also alluded to this court, that this is a case that is specifically assigned to him and to go through the process of all the preparation of bail application. To put the state into the corner, whereby when the bail application is to be started, then the prosecution is not available or is not ready to proceed, it will further delay the inception of this bail application. I am of the view that it is reasonable, it is fair for this bail application to be commenced with on the 11th and the 12th. And if bail application is not finished on that specific date, then it will be determined as to other dates, or further arrangements will be made as to further hearing of the bail application. Right, all the accused will remain in custody until then.
As a place we may adjourn. I need to understand there are other matters to be proceeded with.
Okay, thank you. Court adjourns.
All right.